I have 25 minutes, and the material that I've provided to Lehane is 150 pages. So if I have challenging times ahead in work, I'll have a very challenging next 25 minutes to get through. I will do my best to go in the detail, because sometimes when you rush, you simply lose the train of thought. But I can assure you that the whole talk, and nothing but the talk, is in, and you have 150 pages, and it does go through in a layered way, bringing you through the various stages of the bankruptcy process, and we'll deal with consequences. So given that I've got 25 minutes, I better start. Right, who am I? I'm the official assignee in bankruptcy, the person who is the administrator of bankruptcy estates, and we'll deal with it on the slide. But for the start, we'll start dealing with what is the governing law. The governing law is the Bankruptcy Act 1988, and this is now being amended by Part 4 of the Personal Insolvency Act 2012. I'm also governed by the Rules of Superior Courts, Order 76 and Appendix O, and in time, the Insolvency Service, under Section 3 of the Personal Insolvency Act, the Minister will be making regulations. So as my office moves from the court service, and will be when the Courts Act is passed, and is merged into the Insolvency Service. Well, my position as official assignee, it's a judicial process, so the integrity of the Bankruptcy Act is maintained, and I'm answerable to the bankruptcy judge. If anyone has any complaints with my decisions, it is to the bankruptcy court that they will appeal me. Equally, I can go to the bankruptcy court for directions. And then, of course, I'm governed by EU legislation, the EU Insolvency Regulation, the High Court Fees Order, and in time that obviously we'll be working through with Lorcan and getting a basis for charging fees in bankruptcy. Okay, so what court deals with it? The High Court is exclusive bankruptcy jurisdiction, so there's no applications in the Circuit Court. All applications must be made through the bankruptcy judge. And then we'll deal with the bankruptcy list. Has anyone been in the bankruptcy court? Right, it's a Monday morning, and some can be quite eventful. And we had an eventful day yesterday in the bankruptcy court. Bankruptcy court will deal with payments of all dividends when we actually get cash and we're in a position to pay it out. The grant, and then of course the whole issuance of the bankruptcy summons and the petitions, the grounding out documents, and we will deal with this in huge detail within the talks itself. And then of course the adjudication order, whether it's made by the creditor or it's made by the person itself, the order that makes him bankrupt. And then various applications during the course of the bankruptcy, and then of course compositions if the debtor is in a position to put money together. If you sell a house, there's cash there, and he may be able to do a deal with his creditors. That's what composition of creditors. And then, of course, applications for discharge. The roles. The examiner of the High Court is the relevant court official dealing with the taking in of all applications. The official assignee's role only arises once an adjudication order has been made. So there's a lot of... So if you're filing any documents, petitions, affidavits, everything, it is still to the examiner's office, and the examiner's office is in the court service headquarters, Phoenix House in Smithfield, which where I'm currently based, and over the weekend we'll be moving up with Lorcan into the Insolvency Service. And there'll be a notice. Apparently the position is that you've only been given the actual lectures themselves, and all the appendices will be emailed. Is that right, Nolene?
Sorry.
I'll send you a message. All right, okay. No, it's in relation to the appendices. They're going to be emailed.
No, they'll be up on the website.
All right.
We'll have everything up on the website early next week, so all the appendices will be up there.
Okay. So this is me. This is what I do. I'm the administrator. When a person is made bankrupt, all the estate vests in me for the purposes of gathering in the assets, paying the debts, paying... You know, in some instances it's selling property, in some instances there is property there, and it can instantly be realisable. At the moment, the nature of most of the bankruptcy is negative equity, and my role is mainly surrendering properties back that are in such huge negative equity and getting involved in a huge number of actions and basically scaling them down, because some people are obviously into an awful lot of co-ownerships and partnerships. There's a huge amount of law involved in simply unwinding and basically convincing people that there's no point in suing this guy because he really genuinely doesn't have anything. And in a lot of situations, if people truly understood and statement of affairs could be filed at the very earliest stage, a lot of people would not be bankrupt. But the trend will be, because the discharge period has come down to 3 years, automatic discharge from 12 to 3, will be going like England, which, as you know, is only 1 year, where self-adjudications, people themselves will effectively think, no, this is not sustainable, I can't go on, and I need to bankrupt myself. And in England, the statistics are 85% of bankruptcies are self-adjudications. So then we'll start getting into the papers. So if you start opening up the papers, we'll have a look at the, and this is what I'm going to do. I'll just use this as a heading. We're going to be looking at the process of applying for bankruptcy. We're looking at the requirements to petition on behalf of a debtor, on behalf of a creditor, as amended by the Personal Insolvency Act, because Part 4 of the Personal Insolvency Act is amending, first of all, the amount of debt that you can be bankrupted for and what requirements a judge needs to be satisfied about to ensure that the person is entitled to be bankrupted. And then what are the consequences for a person when they're made bankrupt? For the individual himself, in relation to his debts, in relation to the administration of those assets, and in relation to his income going forward. And then, this is the latter part of the first talk only, and we're only still in the index, the discharge procedures as amended by the Personal Insolvency Act. I have not gone through and said, this is the current, the new ones will change. I presented as it will be, and I believe in late June, the Part 4 of the Personal Insolvency Act will be passed. So rather than there's enough pages you've got, this will be what ye as practitioners will be dealing with. What will be the law as from late June. And then we're back to what are the appendices. I have copied as an appendix the whole of Part 4 for your benefit. Rules 10 to 49 of the Rules of Superior Courts, a glossary of bankruptcy terms, which I would hope you as practitioners would have, but certainly for the layperson, true layperson out there, getting involved in the legal process, as we do in life when we touch in and we go into any new area of practice, or hit with jargon that can be confounding and confusing. And no doubt when a person already has the distress to deal with the burden of the debt, to be hit with legal jargon, we do our best, and certainly everything that's been produced by the Insolvency Service has been approved and will be, to make it in plain English and simple for everyone to understand. And then finally, as a notice, basically getting the message out there, and to hear it's going on a website is great. It'll be on our website and the Court Service website, that my office is actually moving over the weekend and will be located no longer on the second floor beside the examiner's office in Smithfield, where any of you who have had practice would have met me. We'll be moving down into the Insolvency Service headquarters in Cunningham Road. Right, so what we're going to do quickly is, and I'll be watching Noeline because I'm going to be running out of time. So what are the various processes of applying for bankruptcy? So we're turning to page 2 of the handout. Right? Now, the process to initiate a bankruptcy, and I'm mainly going to be talking from the perspective of a self-adjudication, given that most of the people in this room are not here to find out how to bankrupt someone else. I think I can take that.
Yeah.
Yes, all right, go ahead. So a lot of the slant of this was specifically written for yourselves, and there's huge emphasis on explaining if someone is saying, look, I'm going to bankrupt myself, what do I go about it? And the reason I'm saying that, there's a prior procedure if you're dealing with a creditor. Here, when you are the debtor himself who's effectively saying, I can't take this, I need to get out of this, I need the protection of the court. That, if they can't, in the first instance go, and if I was actually organising this talk today, I would have organised it was entirely appropriate that I continue after Lorcan, but I would have maybe someone like Fiona Muldoon from the Central Bank, because what's being attempted is that there is going to be a protocol, that banks are going to be seeking to be engaging as a prior collective process to Lorcan, dealing with the non-bankruptcy process, the debt relief notices, the debt settlement agreements and the personal insolvency agreements, So you first of all try and deal as you should in the normal course without having to get involved in any of the processes. If you can't, you go through the Lehane processes, we'll call them. And if that is not achievable, if what you're proposing isn't either sustained, or if what you offer isn't acceptable, or what they're coming back to you isn't sustainable, well, then your only option may well be to go into bankruptcy. And what I'm even learning new jargon. Rather than talking about insolvency, we're hearing the word distressed. And that what really the banks are at is looking at providing a window where people at some stage believed that they had the capacity to take on this huge debt. And something has happened. Some event, either one of them is made unemployed, or both, or they're sick, and they are not now in a position. What the banks could be attempting to do is to provide a window where distressed and not insolvent people are given an opportunity to various forms of either debt forgiveness or interest only, which obviously has been abused and gone way beyond where that should have gone, to enable them be back on their feet again. Maybe they'll get employment, and they are not necessarily going to have to come to local. And that's obviously the preferable position. And if there's any circumstances in which people, and it is sustainable, and all they need is a job back, and they're back. Because don't forget, people did take on responsibilities. And people who can pay should pay. And no one should be coming thinking that they're looking for negative equity striking out. Negative equity does not arise until such time as you've actually assessed that they haven't got the capacity to pay, back on their feet, and maybe they can keep their buy-to-let, which is maybe what the original plan was and what your advice might enable them to do, right? So I thought that was a way for... Okay, so the first petition, 10 minutes to go, right? Okay, so the procedure is a petition. You petition in the High Court, and the petition appears before the High Court judge, and if the court is satisfied, having regard to your circumstances, and that you've attempted to go through those prior procedures and you haven't been able to do it, the court may adjudicate you bankrupt. And here we'll go through the minutiae of the procedures. And because I've got very tight time frames, I am going to be jumping. It's all here. All right? Bedtime reading tonight. Right? Requirements for a petition for the bankruptcy. A debtor may bring a petition for his own bankruptcy, is unable to pay his debts, and where his available estate is 1,900. That requirement is dropped. That you need to have money in order to, it's clear money to be able to say that you have money to pay to your creditors. Personal Insolvency Act is dropping that requirement. That the debts must be 20,000 or more. That's a requirement of the Personal Insolvency Act. Before it was only €1,900. That the petition must be accompanied by an affidavit which really confirms to the judge that you've attempted to go through, that we'll call them the Lehane procedures. And then there you've got Form 13, and I've got in the index the file path for you on the court service website to find the exact form that you need of a petition. So this should be a great asset to you as a petitioner to know exactly where to go, and it'll tell you what the documents are and where you can find them. It must also contain undertaking that you will advertise notice of the bankruptcy, contain an undertaking to lodge such sum to pay the official assignee. When you're seeking to make yourself bankrupt, there is an undertaking in the petition that you will fund the official assignee to enable him deal with your estate. It may well be a problem when you're bankrupt, but it is a commitment that you're giving in the bankruptcy to effectively enable me do my work, which is to effectively distribute any estate there is and deal with any issues that you've effectively left, because that's what happens. All the hassle and it is a huge relief to some people that when they are made bankrupt, that the letters stop coming. I start getting the letters, so you can imagine what my stress levels are like. And the actions that sometimes I'm thrown in. One person once bankrupted himself, and he was selling tickets for a rugby match. And he simply sent an email saying, Lehane is now dealing with this. And by God, did I have a lot of stress rugby players, not rugby players, would probably wear a couple of rugby players. But so it is amazing how stressed I become and how de-stressed the bankrupts come after they're made bankrupt. Right. And then the next D is when you're drafting your petition, that you have to establish jurisdiction in order to issue that petition. And in the first instance, COMI, Central Main Interest in Ireland. We've heard it because obviously there's a lot of people are heading up and west, east, to maintain that their COMI is other than Ireland. And obviously there's been some high profiles where when it's been challenged, and in challenging that you must go to the court. England must go to Northern Ireland. There's no point in coming to Irish court because under the EU regulation you must challenge it in the court in which the order has been made. Right, so in the first instance the central main interest is Ireland. Or if the central main interest is not Ireland, that you have an establishment within the jurisdiction and you're actually looking to institute secondary proceedings in Ireland. We've never had, believe it or not, secondary proceedings in Ireland. We've only have effectively one bankruptcy. I've never had the experience of dealing with this, which is odd given the number of joint bankruptcies that are across. That the insolvency regulation does not apply to the proceeding in such instances. So if the insolvency regulation does not apply, you'd have to prove one of these circumstances, domiciled, etc. Okay, where the insolvency regulation, I'm skipping down to 4. When the insolvency regulation applies to the proceedings containing a statement that there's no insolvency proceedings have been opened in respect of the debtor in any member state other than the member state, or that such insolvency proceedings have been opened, and if so, whether these are main proceedings. And this is just stimulating that if the central main interest is Ireland, you issue, and the COMI is Ireland, Ireland will be the place where the person will be bankrupted. And if they have an establishment, we say in England, they can issue secondary proceedings. So you have actually two simultaneous sets of proceedings. Okay, E, where the insolvency proceedings have been opened in another member state, the affidavit, and that's simply dealing with, you need to effectively deliver proofs as to why you're maintaining it's that. Where the central main interest is situated within the territory of the member state other than the member state, and this is again just simply dealing with the proofs that you need to prove. A petition for bankruptcy by a debtor shall be supported by an affidavit of debtor setting forth the particulars of assets. Again, this is just further detail. And then upon the presentation of the petition, this is what I've covered before, you have to file €650 in the Office of the Official Assignee up front before you issue your petition in order for the examiner's office to issue that petition. This is to enable, so it is a prior cost. And we'll deal with the cost after. It's about €100 for the actual stamp duty, but there's a $650 upfront cost to provide some funds to enable me administer the estate. And so this does not all impact on the taxpayer. And then we'll skip down to J. The official assignee shall account for the monies. Again, that's just pure detail. The person who you'll be dealing with primarily when you're issuing your petition, if you're acting on behalf of a person, will be what's called the bankruptcy registrar, and that is an official of the examiner's office. So, on the basis that the petition is by a creditor, so a creditor may petition where he's committed an act of bankruptcy, and again, given that primarily here no one is going to be looking for this type of advice, I'm going to skip, but it is all there because there's a huge amount that will be very relevant. Obviously, the tree, which is the consequences of bankruptcy on a person. So, the first thing most people say is, when will my son know? Some people don't tell their own family. Sometimes notices appear in the paper and it turns out that maybe 3-4 months afterwards and they haven't told the family. The bankruptcy inspector in going out to the family home is discreet, and in certain circumstances the wife can be at work and the wife is not even told. I mean, as soon as, and we in the normal course will be getting to dealing with the family home, and we'll actually deal with the family home in a bit more detail later on, but it is amazing how the stigma of bankruptcy is so, crushing for people. Losing their assets, but letting people know that they are effectively failures, whereas in America, a bankruptcy is like a badge of honour where you basically get up and go. And of course, that had a lot to do with the draconian processes and the length of time that you were in. And hopefully with that discharge period comes down, and people who only the people who obviously need to go into bankruptcy and get the debt written off and get back on their feet and get the fresh start, which is the whole point of the modernisations of the Bankruptcy Act in the Personal Insolvency Act. So there's a duty on the bankrupt to issue a notice, and that's what I deal with in 311. And then what are the duties on a bankrupt? Well, obviously it's to fully cooperate with me in relation to the administration of his estate. Can't change his address without notifying me. And then he effectively must make himself available to be served with the bankruptcy order. Again, we're going into a little bit of detail, so we might skip down here 5 minutes. Right? Okay, so there's legal obligations. You must deliver your accounts, you deliver your title deeds, assist me in the administration of the estate. If you fail to do so, I can have you brought before the court, because it is true that certain people are not disclosing all their assets. And it is a huge difficulty for me when there are people saying he's driving around in cars and you're tracing them and someone else has owned the cars. But there is visible wealth there and you're chasing it down. And there are obviously a lot of allegations that there's millions around the country. There are also particular situations where people believe, but the truth of it is, it's the father-in-law is a multimillionaire and he's paying the mortgage and they're still in the family home. And on the face of it, people are saying, how could you not get him out of the family home? If the mortgage is way beyond the value and someone else is wholly paying the mortgage, that is no expense to the it's no expense to the bankruptcy, and also there's no request for reasonable living expenses to pay for a mansion. And people just simply cannot understand that. And they've been done, they believe, and he's living the lap of luxury. And it's to get the balance, because you have to be fair to both the creditors and the debtors in the official assignee. And when you're here, you will be an intermediary trying as best you can to get the best deal to bring it over the line and yet allow it that it's affordable and sustainable for the person who is in the circumstance. And that's why those reasonable living expenses, and you'll see within what we had done already as in the official assignee using the household budget survey, and which is built on and proved by the reasonable living expenses, which is effectively a bit of a hybrid of what we were at, but effectively is using charity ground up research on the basis of charities who've actually looked at the costs, whereas the process that I was using before was the household budget survey, which was averages using the process that is applied in England. Ours is based on charities and is from bottom up on the basis of actual costs that 3 different interest groups in relation to each family unit have said are sustainable. So now, we'll now go on to 3.2, section 136. So what happens in relation to debts? When a person is made bankrupt, section 136 of the Bankruptcy Act says that your only avenue as a creditor is through the bankruptcy process. You cannot issue proceedings. You must simply claim in the bankruptcy. So you can't start issuing summons post-adjudication. I effectively step into the shoes of the bankrupt, and I am involved in actions, winding them down. In some instances, if there's monies, I will be trying to defend actions. And if there is no monies, I will be doing everything I can to get out of actions, because in many of the situations, the amount of cash you would put up might be only trying to save yet another claim, but it would be 100% funds, whereas at the end of the day, you may only be giving 1 or 2 cents in the euro in any dividend. And it is a big scaling trying to work out, is it worth getting involved? And most of the situations, given the nature of the bankruptcy in Ireland at the moment, which is huge negative equity, there are no assets to enable me properly administer the estate. So, when I'll probably finish on this, but I can point you to the secured creditor paper, because one of the most controversial issues, obviously, in bankruptcy at the moment is the family home. And I might summarise it without going into the detail of it. Is it necessary, when a person is made bankrupt, that they lose the family home? Well, if you look at it from my perspective, I'm the official assignee in bankruptcy, and my job is to realise any assets of the bankruptcy for the benefit of creditors. I look at the family home. I see, is there any equity in the family home? If there's no equity in the family home, which is going to be the position, as is the position now in the vast majority, Chris Lehane will not be the one who'll be selling the family home, because there'll be no benefit for creditors for me to sell the family home. And the position going forward will be, will I allow, as part of the reasonable living expenses, mortgage payments that would enable the man or the woman, whoever was made bankrupt, pay towards the mortgage so they can keep the family home. And in the normal course, if it is not a palatial house with an enormous mortgage, I will. Because as part of reasonable living expenses, you would allow rental property monies, you would equally allow mortgage payments. So it isn't necessarily true that when a person is made bankrupt that they necessarily lose their family home. It depends in each case. And even where there is equity, and we use the classic where it's been the man who's got all the debts and the woman, if the spouse has the money, in the first instances, I will not seek to sell the family home, but offer to the wife to sell the family home. And in some situations, that solves the problem. But what it is you are looking at a situation where, in the normal course, people think bankruptcy necessarily means you've lost the family home. It could be that the bank then, because the bank is the deciding, well, once the mortgage is paid, they're not interested. The bank will allow the mortgage to be paid on. And don't forget, the wife is still on 100% on the hook for the joint and several liability of the loan. And in the normal course, that is actually what happens in an awful lot of bankruptcies. What happens? The unsecured debt is written off, and going forward, that's definitely final reminder, going forward, what happens is that the bank may actually start giving, if it hasn't already been interest only, and the mortgage is being sustained, and then he gets a job, she gets a job, and the mortgage continues on. So bankruptcy is not necessarily the end of the family home. I'll leave it.